acknowledge. There we go. Thanks, Patricia. Sorry. I would like to begin by acknowledging that the land in which we gather at capacity is the traditional, ancestral, and unceded territory of the Musqueam. And we are very, very grateful for our ability to be here and on this land. In acknowledging the land, I'd also like to recognize the devastating impact of colonization for violence against Indigenous women, and the work all of us in our reconciliation research to address this sort of violence for Indigenous women and for women right across the globe. So in that, and building from that, it is my incredible pleasure today to introduce Dr. Lara Lynn Hudspeth. And we're really excited to have Lara join us today. Lara is a gender-based violence researcher whose research interests center around the justice needs of victim survivors of sexual violence. She was awarded a PhD in psychology from the University of Huddersfield in the UK in 2022. Lara explored the criminal justice response to sexual offenses via the conduction of interviews with rape victim survivors and criminal justice system stakeholders, and expanded this research within the COVID-19 context, as well as a research associate. And today we are really lucky because we have Lara works with us as a research staff member within the Capacity Research Unit, specifically with the Scaling Up project, which is exploring the process and impacts of outreach with women and youth experiencing gender-based violence. So it is my great pleasure to hand it over to you, Lara, and we look forward to it. And just to let everybody know, we are recording, but you won't show up in our recording. It's just the speakers and the slides. And when we are ready for questions, I'll just ask people to either put up their hands or type it in the chat, and we can engage and have a conversation. So thank you so much and welcome, and I'm really looking forward to it. So over to you.
Thank you, Vicky. So I've started sharing the screen now, so hopefully everybody can see my slides. So yeah, today throughout this presentation, I'm going to be talking about some of my PhD research that I conducted, and sort of addressing the question as to whether the criminal justice system can deliver justice for rape victim survivors. I do have a slide here that was a bit of background around me, but Vicky did such a great job at introducing me, so I'll just be brief here as not to kind of duplicate that. But as Vicky mentioned, my academic background is in psychology, so I completed my PhD in psychology at the University of Huddersfield towards the end of last year, looking at the criminal justice response to rape in terms of people's experiences of rape trials. Initially, I was very much focused on jurors' experiences and trying to develop educational materials for jurors regarding rape myths, so false and biased expectations that individuals might have around rape, trying to address that aspect of things to improve their decision making and make that more objective. But then I very much shift to kind of a broader perspective, looking at more general issues across rape trials and general reforms that could be implemented beyond this intervention for jurors. So in terms of methods, I did a systematic review of rape myth acceptance interventions. This was basically a review of research that had looked at different interventions implemented in different settings, such as universities or with military groups, and I looked at how that could be applied to jurors. But then I went on to conduct interviews with 4 different stakeholder groups to look at experiences more generally and their views with regards to various issues across trials beyond just jurors and biased beliefs. So, of course, I spoke to victim survivors themselves, so individuals that had engaged with this process. I also spoke to independent sexual violence advisors, known as ISVAs in the UK, which is essentially a support worker role, individuals that can work with victim survivors throughout the entire criminal justice process. And these are the 2 interview groups that I'm going to speak about today and talk about some of the findings from those studies. But I also did interview barristers, so individuals that had worked as lawyers, as both on the defence side and on the prosecution side. And I also spoke to individuals that had undertaken their jury duty on sexual offences cases as well. As Vicky mentioned, after my PhD, I then went on to work as a research associate at Lancaster University, looking at the impact of COVID on the criminal justice response to rape. And then following this, I worked as a lecturer in forensic psychology at Leeds Trinity University. And now, of course, now here I am in Canada, working in the capacity unit on the specifically on the Scaling Up project. So as well as giving you that little bit of background about me, I also wanted to provide a bit of information around the criminal justice system in England and Wales, just to give a bit more of that context to some of the things that I'll be discussing today. So as I understand it, the criminal justice system in England and Wales is quite similar to that we have here in Canada and in BC, but there are just a few things that I thought I would mention in some terminology and things like that I'll be discussing today or using today. So in England and Wales, the criminal court structure is hierarchical. So there are several different criminal courts in a hierarchy. So the first court that most cases will go to is the Magistrates' Court. And the Magistrate Court deals with less serious offences, and the cases will be presented to a group of lay magistrates, so untrained individuals that often work this role sort of part-time. And more serious cases are then sent up to the Crown Court. So in the Crown Court, this is where they will hear sexual offences. In a Crown Court, there are two opposing sides. So we have the Crown or the prosecutor and the defence. It's the role of the prosecutor to prove that the defendant is guilty, whereas the defence works for the defendant, trying to advocate for their acquittal. Now, it's a common misconception that the Crown prosecutor, so the barrister that's prosecuting the case, works directly for a victim survivor. However, they're actually working on behalf of the Crown rather than the victim themselves. Whereas in contrast to this, the defence barrister works directly with and for the defendant. In contrast to Magistrates' Court, in the Crown Court, there's also a judge and jury, and the jury consists of between 9 and 12 jurors who are randomly selected from the pool of eligible individuals who are able to undertake jury service. In terms of kind of the timeline and process of Crown Court cases, first the prosecution side will present the evidence, the victim survivor will testify, give their evidence and be asked questions by the prosecutor, and then the defence will present their evidence. And at this point, the defence, so the defence barrister or lawyer is able to question the victim survivor based on the evidence that they've provided throughout the investigation stage and throughout the case in the courtroom, and that's referred to as the cross-examination. I also wanted to share with you the legal definition of rape that's used in England and Wales. I've put that on the slide there for you to read through. But a key feature really to be aware of is that it's a consent-based definition of rape rather than a force-based definition of rape that we see in some other jurisdictions. There are also a few bullet points at the bottom of this slide of just a few other things that I wanted to mention. The first of these is special measures, and what special measures are measures that can be put in place to help a witness in a case give their best evidence, so to help them feel comfortable and supported throughout the process when they're giving evidence and testifying in court. These can be applied for by any individual who's deemed to be a vulnerable or intimidated witness in a case, and they're also automatically applied to individuals in rape and other sexual offences cases. So they're automatically able to at least apply for these in those cases. As I mentioned earlier, we have the ISVA role in England and Wales, so Independent Sexual Violence Advisor, who are able to support victim survivors throughout a case. So in some circumstances, they're there right from the beginning, where a victim survivor is able to get advice from the ISVA with regards to reporting and what that process entails. Sometimes they might be kind of linked up a bit later on, where they're able to give information about the court process. They might be a point of contact between the victim survivor and the police and the Crown Prosecution Service. And they're also able to accompany individuals to court in cases in which the case does actually make it to trial. In addition to supporting individuals through the criminal justice process, ISVAs are also there to assist individuals, victim survivors, with a criminal injuries compensation scheme, so the more civil legal side of things as well. And finally, before I move on to talking about my study, I also wanted to talk a little bit about what justice might mean for victim survivors in particular, and how this might be different to individuals that are victims of other types of crime. So I wanted to introduce the idea of kaleidoscopic justice that was proposed by McGlynn et al. In 2017. So they conducted a study in England and Wales with victim survivors who they interviewed and conducted focus groups with to ask them about their views regarding justice. So what justice meant to them and what did they understand justice to mean. And what they really concluded was that justice can mean many different things to different people, and that even for one individual, their sense of justice and their ideas of justice might change over time. And really, they also found that the ideas that were coming through in the study actually went beyond this perhaps conventional idea of justice that we might have, and an idea of justice that's kind of in line with conventional criminal justice systems, that's very much focused on conviction and punishment. So there were some drastic differences between victim survivors' views and then that conventional idea. So they defined kaleidoscopic justice as a continually shifting pattern, constantly refracted through new experiences and perspectives, with multiple beginnings and no finite ending. Justice as a pluralistic, lived, evolving experience. And some of the key features of this idea of justice are presented on the slide here too. So one of the important things that came through from the interviews and focus groups was this idea of recognition. And that was recognition not only of the fact that something had happened, that someone had been assaulted, but the harm that had been caused by those actions. Victim survivors also spoke about wanting meaningful consequences for perpetrators. And again, this was beyond conventional ideas of just punishment, and was more around prevention of reoffending and actually a sense of accountability from the offender in terms of potentially apologising for what had occurred and what they had done. And finally, they also spoke about voice as justice throughout their study. So this was the idea that not only are individuals able to tell their story in a forum that's relevant to them and in a way that they wish to do, but also having a voice throughout the process in terms of having active participation and being able to be heard in terms of what their needs are and their requests being met and their needs being met. And also while being treated with respect throughout this process. And sadly, what we see from various studies, so not just my research, is that some of these needs and these different types of needs aren't really met throughout a conventional justice process, which we'll explore today. So the overall aim of my interview studies was really to explore individuals' experiences of rape trials. So I was specifically asking what issues did victim survivors face, what issues did the professionals feel that victims faced, and how could these things be resolved, what reforms could be made to the conventional justice system, if any, to actually improve things, to improve the process and improve outcomes. So I conducted semi-structured interviews overall with 9 victim survivors and 10 ISVAs. As I mentioned, these are the groups that I'll be focusing on today, but I also interviewed a group of barristers, so lawyers, and a group of jurors. So I offered participants the choice of having the interview either in person or having a remote interview. And most individuals did opt for the remote option. So I did a lot of interviews over the phone or via video conferencing platforms, and only 3 of the interviews were in person. The interviews lasted between 28 and 80 minutes, and the average victim survivor interviews were much longer than the ISVA interviews, with the average interview lasting 58 minutes, whereas the average ISVA interview lasted 39 minutes. I also gave participants the option as to whether they wanted to share any demographic information or if they'd rather keep that private. Of those who did provide this information, of the victim survivors, 6 identified as female and 1 identified as male, 5 identified as white British, 1 as white European, and 1 as West Indian/white. This group were aged between 28 and 55. With regards to the ISVAs, all of the ISVAs that I spoke to were women and worked with women, as the victim survivor groups that they worked with were women, and 2 of the ISVAs had specialisms. So one was actually a CHISVA who worked with children and young people, and one worked specifically with groups of individuals that had complex needs. I also tried to speak to individuals that were across various different regions across England and Wales. So the red dots here represent the victim survivors that I spoke to and where they were based and the courts that they attended. And the yellow dots here represent the ISVAs and where they worked. So you can see I got quite a good spread across England and also 1 individual based in North Wales. So after I'd conducted the interviews, I conducted a reflexive thematic analysis on the data, and this produced 3 key themes. The first of which was that victim survivors were not central to the criminal justice process. The second was all around the cross-examination, so when the defence barrister would question them on their testimony. And I found that this was quite a difficult process, as the focus of this cross-examination was upon victim survivors' behaviours and characteristics, rather than that being a space for them to share their story in court. And finally, the third theme was around engagement with the criminal justice system and the negative and long-term impacts that this had. So now I'll go on to talk about each of these 3 themes in turn and showing you some quotes from participants across each of these. So with regards to the first theme, in terms of victims not having a central role within the process, we found that a lot of individuals, both the victim survivors and the ISVAs, spoke about victim survivors having a peripheral role in the process, and that the process was very much defendant-led and focused on the defendant's right to a fair trial rather than the victim's needs and the decisions that they wanted to make throughout the process. So often they spoke about having to fight to be heard and that their opinions weren't necessarily listened to, and that overall they weren't able to make decisions. And another key feature of not being central to the process was the fact that they were often not well informed. So this was something that we saw from the beginning of the process, so from police investigations all the way through to waiting to hear on the day that they'd attended the trial when they would be called to give evidence. And this was something that really came through as a key feature for them that really highlighted to them that they just weren't seen as important throughout the process. So with regards to having a peripheral role, lots of the individuals that I spoke to spoke about feeling as though they were just a witness. So they felt that they weren't given any other kind of active role or any options throughout the process beyond those that would be given to a standard witness for any type of case where the individual wasn't actually a victim in the case as well. So Carol, as an example, stated, as a victim, you don't really get any control over it because you're not actually an active person in it, you are just a witness. And Sarah made similar comments, talking about feeling as though she was treated as a crime scene rather than as a person. She said, you're almost removed, you're the crime scene, you're not a person anymore, you are the evidence. So they really didn't feel like a central feature. They felt kind of on the periphery as just a witness. And this was something that was identified by the ISVAs as well. This idea that victim survivors had a peripheral role and the focus was much more on defendants. Danielle stated they're completely on the periphery, they should be treated as central to it because this is something very personal that's happened to them, and they obviously have an interest in the outcome and the process, but they are not treated as such. And similarly, Janine stated, the victims are supposed to be at the heart of everything that the criminal justice system does, and it isn't always like that. It's very defendant-led. It's very much tailored to the defendant's needs rather than the victims. And again, as I mentioned, both victim survivors and ISVAs spoke about having to fight to be heard throughout the process and for victim survivors' needs to be met. So as an example, Becky spoke about having to really, really fight, as she put it, to be able to meet the barrister beforehand. So as I mentioned earlier on, often victim survivors go into the process thinking that they're working with a barrister that's working specifically for them rather than on the behalf of the Crown. And then once they realise that that isn't the case, often they realise that they're not going to be working closely with the barrister and that they might not even have the chance to meet them before the case on the day, the trial on the day. So we often see that these pre-trial meetings that should be offered aren't. In addition to this, Danielle, as another example, spoke about the fact that ISVAs, as part of their role, are supposed to be able to sit with the victim survivor when they give their evidence in court. So they're able to sit directly behind them in the witness box to provide that support to them. And she stated, "I have really big battles about it." And this is something that I saw across several interviews with lots of the ISVAs that I spoke to. And this seemed to be around other criminal justice professionals not really having an awareness of the ISVA role, questioning why they were there, and feeling quite cautious about allowing someone to sit with them because they, as I say, they didn't understand what this ISVA role was and that was part of it. So as I mentioned, a key thing around not feeling central to the case and to the trial was the fact that individuals weren't well informed throughout the process. And we saw this right from the investigation stage in terms of case updates and updates regarding the investigation, and in terms of whether the case was actually going to go to trial. And then even once a victim survivor was told that their case would be progressing to trial, there were often periods of time where they wouldn't hear a lot from the police, and there were big delays between hearing that it would go to trial and actually finding out when that court date was. So this is something that would be hanging over victim survivors for a long time. So as one example, Carol stated that the police, she had a good relationship with the police initially, but then she went on to say, the police were good to start, but there was a massive lull in communication. I just felt completely forgotten. And sadly, the fact that this was so common was really reflected across all of the interviews, as was the impact that this had on victim survivors. So Louise, for example, said, it just overshadowed my whole day-to-day life, waiting to hear what was happening. My sessions with my counsellor became more about that than the actual attack, because it was the anxiety of not knowing what was happening. Jane similarly said, you're just keeping victims in a state of limbo, and it's traumatic. It has a huge impact on their mental well-being. Just waiting in an empty house for those phone calls was really anxiety-provoking. It was incredibly stressful not knowing whether or not the case was going ahead. And finally, another example from Becky, who stated, my life was on hold and I was suffering from anxiety and depression. As it was getting nearer and nearer to the trial, I was just getting more and more anxious about what it would be like and what questions they might ask me, and it was just a horrible time. So overall, apart from with the support from ISVAs, individuals didn't really have a lot of information around what was happening with their case and what it would be like at court. And this was something that was really difficult to deal with, very anxiety-provoking, and often lasted for a long time for people because of the delays in the court system in England and Wales. And this overall had this massive impact on their mental health and ultimately made them feel like they weren't seen as important throughout the case. So moving on to the second theme, which was around the cross-examination. Really this focused on the victim survivors' behaviours and characteristics rather than being a space to share their story. So they often spoke about the inclusion of non-relevant information, so really small details that they didn't feel had any bearing on the case. Barristers also seem to use rape myths a lot, and again this was something that was spoken about both from victim survivors but as well as ISVAs who could speak to lots of cases that they'd attended. And again, just to be clear, rape myths are around false expectations that individuals have around rape cases and false but persistently held beliefs that individuals might have. And I'll come on to some examples of those on the next few slides. So because of this inclusion of really non-relevant information and focusing on the victim's behaviour and myths about rape, often victim survivors spoke about feeling attacked throughout the process, and that actually felt as though they were the one on trial rather than the defendant. And in addition to this, victim survivors also felt constrained throughout the process. So I'll go on to show you some quotes around the ways in which they felt that they couldn't share their story, and that they were really stopped from being able to elaborate on what happened to them and really give a full account and share the details that they felt were most relevant. So in terms of the non-relevant information that was included, both Carol and Jane spoke to this directly. So Carol stated, there was a lot of use of random things from my past that made me seem questionable rather than information about the case. There were certain things that were raised about my past that I think shouldn't have ever been disclosed and used as evidence because they were completely irrelevant. So a lot of the time this was around counselling that she had prior to the assault and prior to the case, around other things that were raised to make her seem questionable and to question her credibility. Jane similarly said, personal intimate information was presented that had no bearing on what happened. Defence barristers can vilify victims in a way that is not supportive of the criminal or legal element of the case. And another example of things were introduced were questions around individuals' occupations, what they did for work, where this had no relevance to the case at hand. So in terms of the introduction of rape myths, one of the key rape myths that was introduced time and time again across the victim survivors cases, and also across many cases that ISVA spoke about, was that the myth that false allegations are common. So one example was provided by Kate, who said that the defence barrister implied that she'd made this story up completely out of vengeance. Others directly called victim survivors liars throughout the cases, or implied that they'd been lying about what happened. And they gave several potential motivations that they suspected might have been the reason for that. So these were things like having had consensual sex with the defendant and not wanting a partner to know, rather than this being a sexual offence. Doing it for compensation. And there was even one example of when a victim survivor had actually moved to a different country after the assault and had to fly back to England for the trial, and the court system essentially paid for that to happen, paid for the flights for her and her family. And the defence barrister really drew upon that in particular and said, oh, I think you've done that just to get this free flight and holiday for your family back to the UK. In terms of rape myths, another key myth that was introduced was the real rape myth, which is the idea that rape can only be considered to be legitimate if it meets certain criteria. And these are things like occurring outside, in the dark, the perpetrator being a stranger to the victim resisting throughout, both verbally and physically, such that they have injuries afterwards and that they should report immediately afterwards. So often defence barristers drew upon these different characteristics, questioned why the account that the victim survivor had put forward wasn't in line with those characteristics, and argued that because of that it wasn't a legitimate rape case and it must have been consensual. So Marie, for example, stated that the defence barrister wanted to make the case that I didn't defend myself enough because I didn't have any scratches or anything afterwards. The final rape myth that I wanted to introduce, well, actually is a group of myths around victim blaming, so blaming of the victim survivors and suggesting that something that they had done prior to the assault had actually provoked the perpetrator and they were the reason why it happened, to try and belittle their account. So one example is provided by an ISVA here, Joe, who said the barrister was addressing what clothes the client was wearing and saying, you were dressed provocatively, and if you weren't dressed provocatively, maybe this would never have happened, and you've been given the wrong signals because you were dressed like this. And again, these were things that were common across the various accounts that we heard, and indeed has been found across various other studies in England and Wales. So because of this focus on irrelevant information and the use of these and other types of rape myths, victim survivors often stated that they felt attacked throughout the cross-examination. For example, Jane stated, it felt like an attack on my whole self, on my integrity. The barristers tear witnesses apart on the victim stand in any way they want. And similarly, Carol spoke about the cross-examination as a character assassination and an attack. So as I mentioned, in addition to this, throughout the cross-examination, victim survivors often felt that they were constrained throughout this process. So they weren't in a safe space where they were able to share what had happened to them and elaborate and talk about the things that they felt were important. Often they were asked to just simply give yes or no answers, and they were often shut down when trying to elaborate further. So I've got a few examples here on the slide. I'll just read through one of them from Carol, who said, "I wasn't given an opportunity to answer my questions. I kept being shot down. I would try and answer a question and they would say, we want a yes or no answer. But if I tried to say no, here's my reason, because the answer needed more of an explanation, they wouldn't allow me. The judge also shot me down a few times. I wasn't able to give the answers that were appropriate. I was being silenced throughout because my responses weren't what they wanted to hear." So the final themes around the negative long-term impacts that engagement with the criminal justice system had on victim survivors. So this was true both in terms of the process and the impact that that had, and the outcomes themselves in terms of the verdict. So we found that often victim survivors didn't necessarily feel a sense of justice after a conviction in a case. So even where a case resulted in the defendant being found guilty and potentially having a prison sentence, victim survivors weren't necessarily happy around that. And that was to do with the fact that their sense of justice and their understanding of justice wasn't necessarily focused on this idea of punishment and conviction. And so some actually felt a sense of guilt themselves around that, and weren't necessarily happy to hear that an individual would be punished at the end of the case. And we'll go on to look at some of the positive factors of the verdict that kind of contrasted to that and represent that different idea of justice that victim survivors might have. But in addition to this, the process itself was, as we can see from looking through the cross-examination, some of the experiences explored on the previous slides, that the overall process was seen as re-traumatizing for a lot of individuals. And this had a really negative kind of knock-on effect on their mental health and other areas of their lives. So even where an individual was in a case where the defendant received a guilty verdict, and that they might have been happy with that, there were still these other negative impacts that bring into question whether this is a just process. And finally, individuals spoke about the need for aftercare because of the negative experiences that they had. And again, this was something that was advocated for by individuals where the case had resulted in a guilty verdict. So even after receiving that verdict, people still felt that there were negative impacts to such a degree that they needed further support just for having gone through the process. So as I mentioned, a few people spoke about their case resulting in a guilty verdict, but them not necessarily being pleased with this in the way that some individuals might expect. And in fact, that some people in their lives, so their family and friends, actually, were confused by this response. So Kate, for example, spoke about the fact that if the case had resulted in a guilty verdict, she still would have felt guilty. So she said, "I still would have felt guilty if the offender had been convicted because the kids would have lost their dad." Similarly, Sarah stated that when she found out that the defendant in her case received a guilty verdict, that she said, "I slumped back in my chair and thought, I don't want this. I didn't get any pleasure out of taking 6 years of somebody's life." So I think this really highlights that a guilty verdict, isn't necessarily the be all and end all to an individual in terms of what they're seeking when they're looking for justice. So instead, key features of justice for some individuals was around being believed, receiving validation, so that recognition that we spoke about earlier on, and also to prevent reoffending. So in terms of belief, this was again something that we saw across many of the interviews where individuals felt that a guilty verdict really represented to them that they had been believed and that was really important to them. So Jane, for example, said, "For me, knowing that a jury believed me because they gave a guilty verdict has very, very possibly been the most healing element of my recovery." But again, Jane, for example, went on to say that to talk about formal validation as well and how important this was, and that the verdict represented not only belief but validation, and that was key. She said, just having that formal validation and the justice has been absolutely crucial to me. There's been lots of things that I've had to try and do and recover, but having that in my back pocket, that guilty verdict, it made an enormous difference to me. Nobody can take that away from me. Nobody can question that or doubt me. And interestingly, we also heard that this validation came not only from the criminal justice process, but through individuals going through the criminal injuries compensation, so that more civil, the civil side of things in civil cases, in that a successful criminal injuries claim also really felt like a sense of justice for them too. So the individuals that I spoke to that had gone through the criminal injuries compensation process really spoke about the fact that they hadn't done that to try and receive the money. It wasn't about the financial compensation. It was about the symbolic meaning that had. So Sarah, for example, said that this felt like validation because they believed me. They believed that an offence had occurred after looking at all the same evidence that would have been provided in the criminal case as well. And finally, individuals spoke about the fact that a guilty verdict wasn't about punishment, but it was about preventing reoffending, which again is something that we see across different studies. So Louise said, I always thought he's going to carry on doing this if he gets away with it. So for me, a guilty verdict would have made sure that it didn't happen to anybody else. So just to summarise there, we can see that the outcomes of cases might not necessarily be completely in line with people's sense of justice in terms of a guilty verdict and punishment not being the focus for victim survivors. As I mentioned, the process was seen to be re-traumatising for many victim survivors. So some of the individuals that I spoke to talked about the fact that the cross-examination in particular throughout the trial was actually very similar to the assault itself in terms of the way it made them feel and losing that control. So Becky, for example, said that throughout cross-examination, you're just frozen with fear and panic and you can't get away. She said, it's just exactly like when you're being attacked, you're just trapped there, you can't say anything. It's the same feeling, you're trapped, you can't get away and you have no control. Carol similarly said, the feeling of being silenced throughout cross-examination and not being able to have my say, it takes you back. So because of this, individuals spoke about the key impacts this process and this re-traumatizing process had on their mental health. Becky in particular spoke about developing PTSD. Specifically, she said, I have terrible flashbacks to giving evidence in court. It really was the worst experience of my life. I've got PTSD, which is severe, and that was caused by giving evidence in court, not the actual original assault. So I think that really highlights the impact that going through this process can have on people and how re-traumatizing it is. Carol similarly said, it makes you feel worthless and unimportant, and it leaves a lasting effect. And finally, Louise stated, the psychological impact of the trial really got to me for months and years after about the things that were said. For a long time, the process of what happened and how I felt about not getting my say really impacted me. The trials also seem to impact on individuals in terms of having a knock-on effect on their work. So both Becky and Louise spoke about being off work for a long period of time due to the symptoms of feeling re-traumatized throughout the process. And others also spoke about this impact that the re-traumatization had on their recovery after the assault and trying to kind of rebuild their mental health. Carol in particular spoke about feeling as though counselling wasn't a safe space for her anymore because her counselling notes had been introduced throughout the trial. And finally, Nicole said that the cases, whether there was a conviction or not, has a long-term impact on somebody. It can impact on somebody's recovery. And this was specifically around the cross-examination again. So as I mentioned, because of this re-traumatization that people experienced, many spoke about the need for aftercare at the end of a trial, and they spoke about the fact that they don't necessarily have that support at that point, is that because the end of a trial is seen as it's all kind of done and dusted, you've had the support you need, and that's that. And as I mentioned, what was interesting was that individuals whose cases had resulted in a guilty verdict for the defendant, they still felt like they needed that support. Again, highlighting that a guilty verdict isn't kind of everything that somebody's hoping for, and doesn't necessarily fill the justice needs that somebody has. So Sarah said, people assume you get closure when you've had a court case, but no, you don't. They think, yes, he's got 6 years, you must be so thrilled. Well, no, I'm not. I just want some peace. That's what I want. And a longer quote here from Becky that I think is important to share. Becky said, after the court case, everyone was going, oh, that's great, it's over now. But for me, that was just the beginning. You get no support whatsoever. You're not dealing with the police anymore. You don't have an ISVA anymore. I'd been dropped and abandoned from the system. After the case, I never felt so low in my life. I didn't get out of bed for 3 days. My emotions felt like they had dropped off the edge of a cliff. There needs to be some support for people after they've been to court, because for everyone else, getting a guilty verdict was really good. But for me, my life had been on hold. I had all of these emotions and I just didn't know what to do with them. So I think both of these quotes here really highlight that need for aftercare, and again reiterates the fact that criminal justice process might not actually end in the resolution that individuals might expect. So to conclude, sadly, I saw throughout these interviews and throughout the 3 themes that emerged from the analysis that actually individuals' justice needs often aren't met. Victim survivors aren't given the chance to have active participation throughout the cases, or when, in terms of the individuals that I spoke to, they often felt that they didn't have a voice throughout the process, both in terms of making decisions, but also being able to present evidence and share their story. The cases ultimately had negative long-term impacts on them, mainly around the cross-examination process. And the outcomes were not necessarily aligned with their aims of reporting or their justice needs. So the result of a conviction and punishment wasn't necessarily their focus. And what they really focused on was that feeling of being believed, validation, and wanting to prevent reoffending. So I guess that kind of answers the question that conventional criminal justice systems might not actually produce that feeling of justice that individuals are seeking when they do report, which brings up the question of whether we need to explore alternative routes to justice and what they might be. So could that be addressed by reforms to conventional criminal justice systems? Can we improve the ways in which individuals can have active participation throughout these cases? Are there other reforms that can be made? Should individuals be encouraged to go down a restorative justice route? Maybe that would be appropriate for some individuals that might meet some of these points around belief and acknowledgement and accountability. Or can we incorporate some restorative justice elements into more traditional processes? Ultimately, I don't know what the answer is to that question, but I will just leave this presentation on saying that whatever the answer is, I think we can all agree that more does need to be done, and we need to be looking at what individuals' justice needs are and changing things so that they can be addressed. As I say, I'll leave it there. Thank you.
Wow, thank you. Thanks so much for a great presentation and lots of learning and insight. And yeah, so I'm before I wax on or ask any questions, I'm going to open it up to folks here. Feel free to turn on your camera if you'd like. Yeah, so I will just open it up. Does anybody have any questions?
Hi, Lara. Can I just in and ask a question?
Sure.
Well, I'll actually first say thank you so much just for sharing your findings and your work. I think it's such a huge contribution to what we know and don't know about the criminal justice system. My question is just sort of your thinking around like how do you feel this work that you've done and the women's stories could imply? Like, what are sort of some of the implications to the structures that we have to live with that consistently re-traumatize and re-violate women in this type of a situation?
Yeah, well, I think there's lots of recommendations that could be made. that really kind of map onto these justice needs and what people are seeking from the process, the difficulties that they face, and how things could be changed to kind of avoid that. So I think some of the key things would be really involving victim survivors throughout the cases more. So having those key points to make decisions, so around special measures, around having an ISVA supporting and things like that. But also, I think the key thing is to really just change the culture of the courtroom in terms of the information that the barristers use and what they draw on. And of course, there have been attempts to try and address that in some way, but I think that it really reflects that this is the nature of an adversarial system where we have two barristers kind of going head to head, as it were, that's really difficult to change. So we see some change in terms of in the UK at least around restrictions on what can be introduced with regards to sexual history evidence and specific things like that. But I think much more needs to be done in terms of what can be said in a court, and around outright accusing victim survivors of being liars and some of the ridiculous things that are introduced to try and question people's credibility. So I think that would go some way into helping the process, but I just wonder if that will be adopted and how uniformly that would be adopted as well is another question.
Great, thank you so much, Lara.
Thanks.
I'm just checking our chat here. Nope. Anybody, any other questions or comments even for folks that are looking in the Canadian system and that kind of thing? Anything anybody wants to share? Hi, Carrie, go ahead, please.
Yeah, I don't really have a question, but I used to, in my role as a victim service worker before, I supported clients going through the court system. And I just want to say, well, first of all, thank you so much. It was so informative and helpful, and it definitely echoes what's happening in the Canadian system. It like to a T. It's like pretty much exactly what's happening. That's like what a lot of like my experience and a lot of my colleagues would probably say the same thing, that that's exactly how victims feel and survivors feel in the Canadian system as well. It's definitely a lot of back and forth and really not set up to support survivors.
Yeah, I can imagine.
Yeah. But yeah, that's all I want to say.
Thanks.
Thanks, Carrie. Anybody else have any questions as I scan across the screen or comments? Yeah, so feel free to jump in, but Lara, I just want to say it's I was thinking about having done some of this work like 20-25 years ago, and it's really, it almost seems it was bad then. It feels almost that we haven't really made a lot of progress in changing sort of how the whole criminal justice system works. And but I think I was really interested in the idea of what this I think we were talking a little bit before about this idea about the experience being really so negative that people also don't want to, wouldn't necessarily do this again. They wouldn't report in this again. And I'm just wondering if you could talk a little bit more about that, sort of the impact that this has, and being such a negative system for all of us who work in kind of, in violence in this kind of way, when, we've been supporting people to report and that kind of thing. Just any of your thoughts or reflections on your learnings around the impact that this has for people coming forward in the future.
Yeah, it's really difficult because you can understand why people won't want to report because of these experiences that people have. And I think it's made worse by the fact that, at least in the UK, there are so many delays to the system as well. So it's such a long process even to get to the trial, and then for it to be so disappointing almost, and to be such a negative experience. I think that makes it that much harder for individuals that have gone through the process, because it's such a letdown, because you've been waiting for so long, and then it's perhaps not what you thought, both in terms of the process and the outcome. And I think that's what's really difficult to tackle, is the fact that it's not just one or the other. It's not just that the process is really difficult and then it's kind of worth it for the outcome. It's both that even the outcome might feel underwhelming, even if it's what you've initially set out to have. So I think that's what's made me really consider how well suited is the criminal justice system to actually resulting in justice for individuals, and do we want to encourage people to report, or are there other avenues that certain individuals at least might want to look at? Yeah, so it's really difficult in terms of, you know, working one-on-one with victim survivors that have you know, reported something to you, and whether they want to go through a criminal process or not. But yeah, it's just, I don't want to be pessimistic about it, but it's just really difficult.
Yeah, no, thank you. It's I think it is, right. I think it is one of the greatest challenges we face in terms of how the system works to support people, and what happens in those kinds of things, and you know, and the resources that get put into, and you know, the criminal justice system for this, but the impact that it's having. So I just, again, will echo just a huge thank you for sharing, and just for so elegantly bringing the voices forward for people that who have gone through this, and I just want to commend, like, all the use of quotes. So, like, you could feel it, right? You can feel that impact. So thank you for giving visibility to folks, and maybe it's validating in a whole different way to know that their stories get shared. So yeah, thank you. So I will open it one more time for anybody for last comments or questions. Just looking. I know for so we have a question here. Strikes me some of the conclusions you have drawn are the basis of some of the work abolitionists are doing. Wondering if you have come across any of that work.
So I'm probably not as familiar with a lot of that work as I perhaps should be, largely because, as I mentioned at the beginning of my presentation, at the start of my PhD, my focus was very different, and it was only as things kind of evolved that I really shifted my thinking and thought, actually, how much can we improve the justice system, and should we move away to something else? So I think I'm still in kind of the early stages of my thinking with regards to that, and kind of reading up on the literature around that. Thank you.
Great, thank you. And anyone else, any comments or questions? Yeah, and if not, then I will say thank you again, Lara, for just a fantastic presentation. And the recording will get downloaded and be available. I know there's a lot of people who I heard from who are excited. They weren't able to come today. So thank you so much for sharing it with all of us today, and for those of us who are going to listen to it in the future. And yeah, I just really want to just take a moment to consider, the work that many of us are doing in this context, and how we support people, and what this kind of looks like in these contexts of violence and trauma. And so I will be very happy to share this talk with folks, and I'm just thinking of the policy implications and sharing, across different venues, and with people who are really interested in trying to improve the justice system and that kind of thing. So on that note, thank you everybody for coming today. We will make the link live on Capacity as soon as we have it. Lara, thank you so much, and I look forward to what you're going to do next. I think there's so much to be done, and just feel really lucky and fortunate that we get to have you here with us, and get to learn and work with you. So thanks to you, and thanks to everybody, and I hope that you enjoy the rest of your afternoon. And we will be back in January, late January, with our next speaker and that kind of thing. So yeah, we hope you'll all join us again then. So have a great afternoon, everybody, and thank you.
Thank you, Vicky. Thank you, everyone, for coming. Bye.